and share my screen. So, oh, desktop. And let me know if people can't hear me or if there's any technical difficulties. Never know with Zoom. Okay, so we are focusing on the second aspect of homicide this week, which is manslaughter. So I mentioned last week, when you are doing a homicide question, you want to consider both murder and manslaughter. Obviously, if you can make out murder, which is the higher threshold, then you wouldn't consider manslaughter. But if you think it's manslaughter, you still want to go through and say why it's not murder. So um, I don't know if they've mentioned that in class. Like they definitely did it for us, and then they told us right before the exam you need to mention everything when it's a homicide question. So just kind of keep that in mind. So homicide questions do take a while to answer because there's so many elements. So I wish to just do the acknowledgement of country. So acknowledge the people of the Kulin Nations on whose land I join online from today, and I pay my respects to elders past, present, and emerging. Quick note on academic integrity, as always, the LSS strictly condemns academic misconduct and has a zero tolerance policy for people who are found to have breached their academic integrity. And that's just by misusing these educational services. So these are a supplement for you guys to your faculty run classes, and you should use them. But if there's any discrepancy or any sort of difference between what I say and what your faculty says, then always listen to them, because at the end of the day, they're going to be the ones marking your exams. It will not be me. Um, and just a quick note on our sponsors, which are the following law firms. So, Cause Chambers Westgarth, Clayton Utes, Kingwood and Mallisons, and Gilbert and Tobin. So, just thanking them. Um, okay, and this is where we are in the course. It's really makes me happy for you guys to see this, because we're literally basically towards the end. This is like the last offence we'll be studying, and then we'll be doing defences. And defences are really nice and easy. It's just kind of going through the legislation. So yeah, we are pretty much done. And then in week 12, you guys will be doing obviously revision for everything. Um, and assignments, so you've done the two substantive assignments, and now you've just got the exam to worry about. Okay, so manslaughter. I just quickly, before we go through the elements of manslaughter, I just quickly want to go through a bit of background on it, because I think it's really important to understand, um, the history, like for some of these offences, and how the laws developed, and why manslaughter and murder are two separate offences, because previously they were the same. And so, yeah, it's really important just when you're answering questions as well to understand, like, I guess, the policy justifications behind the law. That's going to really allow you to have a deeper understanding and get those higher marks as well. So, the Model Criminal Code Officers Committee established to develop a uniform criminal code across all Australian jurisdictions. And it basically comprised of legal experts and representatives, tasked with modernising and harmonising the criminal law. So this was done a couple of years, not a couple of years ago, a while ago. And when they were drafting sort of homicide and the crimes and the crime of homicide, they wanted to clarify the principles underlying murder and manslaughter, and that's why they sort of created two separate ones, ensuring that the law reflects moral culpability and aligns with public expectations of justice. So, in the next couple of slides, I've just got some really quick questions with answers for you guys just to have a think about why the committee did these specific things. Look, you're never going to like raise any of this in a problem scenario, but it is really important, I think, to understand. So first of all, why did the committee think a guilty state of mind is the best criterion for determining the fault for homicide offences? And that is because it obviously avoids the public scandal of convicting on a serious charge people who are not blameworthy. So, you can imagine the public scandal if someone killed someone while they're sleepwalking and they didn't even know that they did that. So that's something to think about. How did the committee conceptualize the difference between murder and manslaughter? So this is important. So the murder-manslaughter distinction reflects the degree of seriousness of the offence. as connoted by the fault element. So that's why when you're going through a homicide question, you want to discuss murder first because it's the higher threshold, it's the harder one to prove. So obviously with murder, it's intention or recklessness, whereas manslaughter is a sort of lower threshold, a lower threshold of mens rea. Um, and then the conduct undertaken in the knowledge that death was merely a possible consequence makes the offender guilty of manslaughter, but not murder, in most, if not all, Australian jurisdictions. Got two questions left. So why did the committee recommend against one offence of unlawful homicide? So they wanted to emphasise the value of public understanding and acceptance of laws that reflect the fundamental distinctions of common morality, and abolishing the murder-manslaughter distinction will leave the trial judge with no indication of the relative culpability of the defendant. Um, so obviously I've said they're different, but like they still fall under the unlawful homicide, but they are two different offences, and that's why you guys obviously studied them differently. Um, and so why was this distinction made? So when you see a phrase such as first degree murder, it comes up a lot in like movies and TV shows. Um, And that's the deliberate subordination of someone's life. So someone killing someone with the purpose. So examples of this are like killings for political motives. So terrorism or assassination is first degree murder because they went out and intended to kill that person for a specific purpose. Um, Repeated intentional killings where the repetition manifests contempt for human life. So that's like, I don't know, the Ted Bundy or all those cases where people you know, repeatedly kill people for a specific purpose, and then cases of killing for pecuniary gain as well. Um, cool. So now we will go through the elements. I've just got a quick question, so we'll answer that if I can find the chat. Okay, there you go. Um, no, so you don't need to know. The question was, do we need to know this in depth, the committee justifications? No, you don't, and you wouldn't probably raise it in an exam. You definitely wouldn't. It's more like if you were asked to do an essay on it, then you need to know the policy justifications behind it. But no, you don't need to worry about that. It's just more for your understanding of why these two offences were created. Because at the end of the day, the end result is still that someone's dead. So, there's been a lot of discussion of why, if someone kills someone, why should there be different offences for it? Why should someone be guilty of manslaughter and someone guilty of murder if the end result is still the same? And here we're just talking about, the fault element and the mens rea. But no, don't worry about like writing this down or having it for your exam notes. Just more of an understanding. I think it's really important because sometimes we can get caught up in just going through the elements of offences and not understanding the law behind it. Okay, so involuntary manslaughter is broken up in between two sort of offences. So the first one is unlawful and dangerous act, or UDA, and then the second one is criminal negligence. So we'll go through this one first, and then we'll go through the criminal negligence one. So the first aspect of unlawful and dangerous act is in the name. Unlawful act is the first sort of thing you have to prove. So what you would say in an exam, you would go the act of, so let's just say someone, I don't know, slapped someone in the face or someone committed assault. Act of slapping or punching someone in the face is unlawful as it is, you say, common law assault or whatever it is, and is hence in breach of the criminal law. So it could also be a sexual offence. Keep that in mind. So, um, you know, as long as it's an act that's in breach of the criminal law, that means it's unlawful, and that would be enough to prove that. Um, so then you would say common law assault or this sexual offence or whatever the unlawful act is would subsequently become the foundational offence. And the prosecution must prove the requisite actus reus and mens rea elements of the offence. So this is the little paragraph you'd have in your exam. And so it's pretty easy to, it's pretty easy to make out if it's an unlawful or not because you've learnt what unlawful offences are. So if if it's someone like spitting on someone or something, that's not going to be unlawful. So it wouldn't be, you, yeah, it wouldn't kind of fall under this, but make sure that you say this next sentence. So it would become the foundational offence, and then you would go through the actus reus and mens rea elements. And I just have a note here to obviously see topic 4 for the elements, or topic 5 if, so for example, the relevant unlawful act is a sexual offence. And you've already done that. So that's actually in the exam, I'm guessing there won't be topic 4 because it was your mid-sem assessment, but you still then need to know what common law assault is and what the elements are because you need to write it down here. So just remember that because a lot of people just go, okay, cool, it's not in the exam, I'm going to forget all about it, but just make sure you know the elements for it because you need to prove. Cool. And then the next bit is dangerous act. So you've proved that it's an unlawful offence. It also needs to be dangerous. Um, Look, most of the time when it's an unlawful offence, it's also going to be dangerous because that's why it's unlawful, because it's dangerous. So they kind of go hand in hand. But what you'd say for this is the unlawful act must also be objectively dangerous. So it's an objective test. And you would sort of say, making out this element, a reasonable person in the defendant's position would have realised that performing the act would expose V, so the victim, to an appreciable risk of serious injury. And that's the case of Wilson. So that's your relevant authority. You don't need to say anything else for that, just that it would expose the person to an appreciable risk of injury. Of serious injury. Just a quick note, the serious injury, I guess, doesn't need to be as serious in the same way with murder. So if you remember, for recklessness, for murder, the act must have put a person in a position or foresee the sort of risk of serious injury. It's not the same threshold, I guess, because, and that's pretty obvious because this is a lesser offence. So just some interesting cases in regards to dangerous acts that you could raise, and these are on your reading guide. So R against Lamb was a case where the defendant pointed a partly loaded revolver at the victim as a joke and accidentally pulled the trigger and killed the victim. And so here it was found that the defendant actually lacked the mens rea for assault. So it had to be proven that, assault was made out as the foundational offence. And they lacked the mens rea because they accidentally pulled the trigger. So it was found that there was no foundational act, unlawful act. Tremble, I'm not sure how to pronounce it, Pemble, against R. So that case was where the defendant approached the victim from behind with a rifle, wanting to scare her, and then the rifle discharged, killing the victim. The victim did not apprehend harm as she faced away from D. So there was sort of no assault with that because she didn't apprehend any harm, but the act of discharging a firearm in public was dangerous and unlawful. So I think the difference between these cases is that this was like an actual rifle in the second case, whereas this one was like a party loaded revolver. So it was kind of two different arms that they had. But I guess if you have a case where, someone's carrying around a gun and then accidentally discharges it, you can say that, the act of discharging a firearm in public is dangerous and unlawful, even if they didn't mean to do that. I think, yeah, that's kind of similar to your assessment, but different factual scenarios, obviously. Then there's this really important one punch rule. Definitely make sure you've got this in your notes and you know it because it does come up a lot. And basically, all it's saying is that if someone punches someone or strikes someone and that strike or punch is delivered to any part of a person's head or neck and causes injury to that part, it can be assumed that it's a dangerous act for the purposes of manslaughter. A single punch or strike may be the cause of the person's death, even if it results in another injury, which then causes death. So why was this section introduced? Well, it was argued in previous cases that punching someone isn't a dangerous act, especially if you only punch them once. But so they kind of introduced this to say, well, if you punch someone really hard and they hit their head on, the concrete or something, and they subsequently die, you were the cause of that death, even if you, I guess, didn't mean to kill them. So yeah, I guess this is a kind of low threshold. If a punch is administered, then you can assume that it's a dangerous act. If it's to a person's head or neck, if it's to someone's legs or other body parts, then probably not. So this is just the important case to note for unlawful dangerous act, and I had it in my previous slide. I just had the quote from it, but just important to understand the facts. So um, Wilson hit the deceased or the victim on the face, causing them to fall on the ground and hit their head. Wilson's companion then threw his pockets and smashed his head on the concrete, and the deceased died from brain damage. Um, and the Crown suggested that the most likely cause of death was from the fall from the punch. Um, and so here, it was found that assault was made out, the foundational offence, because he intentionally punched him. I think that's very easy to make out. If someone punches someone, most of the time it's intentional. So the quote, though, is important that circumstances must be such that a reasonable man in the accused position would have realised that he was exposing another or others to an appreciable risk of serious injury. So that's the objective test that I had in my previous slide. Um, so yeah, and just note that the injury is not sort of the same as for murder. So they were convicted for manslaughter. Wilson was. Okay. If I don't have any questions on that, so that's the first sort of type of manslaughter, which is unlawful and dangerous act. And then the second one is criminal negligence. Now, a lot of the time in problem scenarios, both of these will actually be relevant, and so you'll need to discuss both of them. In my problem question that I've got at the end, we will discuss both of them. So just know that it's not one or the other usually. So just an introductory thing. So this is from the, why can't I say these cases? Needham case? Needham? That's so embarrassing. I can't say that. Anyways, so the important quote here is the act which caused the death was done by the accused consciously and voluntarily without any intention of causing death or grievous bodily harm, but in circumstance which involved such a great falling short of the standard of care which a reasonable man would have exercised, and which involved such a high risk that death or grievous bodily harm would follow, that the doing of the act merited criminal punishment. So this is a really long quote, and they've just worded it. This is from the case. I didn't write this, so I don't know why it's worded in such a complicated manner, but just read that again. Maybe I'll just give you like 20 seconds. Just read that again. It's really important to understand the threshold for criminal negligence. So the problem with this quote is that a lot of students use this direct quote in their notes and then in the exam, and this probably takes you like 2 minutes to write out, and it also doesn't really make much sense. So I guess understand it, but try and paraphrase it as best as you can. Do not include that whole thing in your problem question. So basically what it's saying is a killing that occurs through a very high or gross degree of negligence is sort of someone can be liable for manslaughter. Okay, so there's a lot on these slides. I'll quickly break it down because these are sort of my summary slides. This is kind of what I had in my exam notes, but then I do have some slides describing the cases a bit more, but you don't need to know the facts super in depth for the exam, obviously. Just know what they were sort of about, and I included that in brackets. Okay, so the first thing that must be that the prosecution must prove is that the act or omission was in breach of a duty of care. Okay, so in relation to acts, there is a general common law duty not to cause harm to others. So that's implicit in that case. But issues arises largely in relation to omissions. So with the breach of duty of care and criminal negligence, most of these cases will be about omissions. So it'll be about someone not doing something, and it's a question of should they have done it, or did they have a duty to do that specific? So that's what the omission is. So a person has no criminal responsibility for negligent conduct, so omissions, unless that conduct involves a duty of care to others. So this is from Burns. So the questions are what duties owed, um, and we need to make a distinction between a moral duty and a legal duty. Okay, so for example, if you're at the beach and you see a stranger drowning in the water, um, if you're just a normal kind of individual who's just laying there at the beach, you might have a moral duty to go and help that person out. You probably do if you're a good person, but you don't have a legal duty. You can understand why that is. Otherwise, we would have a legal duty to help everyone out in every single circumstance if we're walking down the street and see someone fall over. So there's a moral duty and a legal duty. We're only looking at the legal duty. Um, but in that same scenario, so if you're at the beach and you see someone drowning, and you are an accredited lifeguard, for example, but you might not be on your shift, but you're an accredited lifeguard, or you're a doctor, or you're a professional swimmer, you're an Olympian, um, you probably do have a legal duty to go and help that person out if you see them, and if you can reasonably do so. So I guess it comes from each circumstance of the case. You can see, and each facts of the case, but make sure you know that distinction. Um, so there are some legal duties that have been found by cases. So one is the being dependent, the dependent family relationship. So parent-child. So the parent has a legal duty to look after the child. That was the Russell case. Creation of a hazardous situation. That was Miller. So if you start a fire, it is your responsibility to put it out. So you are put in a legal duty if you create a hazardous situation. If you're a chemist and you dabble with chemical compounds and then something happens, it's your duty to kind of um, resolve that situation, I guess, and not put people in danger. Then there's a voluntary assumption of duty for a person who cannot care for themselves. So that was Stone and Donaldson. So that was the case where there was a deaf and blind appellant, um, knowing the poor condition of the victim but failed to care, and the victim subsequently died. Um, and then sort of seclusion as well as an important one. So that was Tac Tac, which was the case in which a prostitute was overdosed and died later due to the fact that A assumed his duty of care by taking her from the street to a house, isolating her from assistance. So I remember we had a lot of cases like that. And sorry if these facts don't make much sense. These are just the condensed notes, something that you guys should probably have. But I do have some slides explaining these cases. Um, but we definitely had a lot of problem scenarios where there was like someone voluntarily secluding someone and then not allowing them to get assistance. I think that was similar in your assignment. Obviously, your assignment wasn't testing manslaughter, so it's completely different. But like, I think someone secluded someone and took them to like an alleyway and then punched them or whatever. So if someone secludes a person and then like kind of inhibits them from getting medical assistance, that can also be a reason for an admission. Um, just note the relationship between supplier of prohibited drugs and recipient is not a legal duty. So that's from Burns. The second element that must be that the prosecution must prove is that the A committed an act or omission um, to do an act that caused the death. Does that make sense? So if they intended through the act or omission to cause that death, um, sorry, not intended. If they intended to do the act that they did, which then caused the death. So they, for example, in the Tac Tac case, you could say that Tac Tac secluded the prostitute and did so with intention, and then that resulted in the death. And the third element and the last element is that the act or omission amounted to criminal negligence and merited criminal punishment. So, first of all, it must have involved a great falling short of the standard of care which a reasonable person would have exercised in the circumstances, and involved such a high risk that death or really serious bodily harm would follow as a result of that act or omission. So, in this case, the Needham case, A came to a barber shop with a bucket containing petrol. He lit up the cigarette lighter and caused an explosion. And then Lavender case, there was a truck was someone was driving a truck towards a group of boys and ended up killing one of them. So both of these acts involved a high risk that death or really serious bodily harm would follow. Um, and yeah, I guess it's just an objective test. So make sure you know that. But facts and circumstances known to A are also relevant. That was found in Lavender. Um, but it does not include A's opinion. So whether A or the defendant thought it was safe to act, or whether they thought they would be putting people in danger. Um, yeah, it's an objective test. So these are just some of the cases that are relevant. So we spoke about this one, and yeah, basically it was here the main thing you need to take away from it is the objective test. So would a reasonable person foresee the risk of death or serious harm? Um, Obviously, you know, if you go into a shop and set someone on fire, you can kind of predict that that would cause injury or death. Lavender as well. So the one that was driving the truck and then ran over someone has found that obviously malice is not required for manslaughter, otherwise it would be murder. It reaffirmed the objective test. Um, and then just in regards to the reasonable person test, just make sure you know that it's, you know, the person's age, their knowledge and experience. So it might have been different if the defendant was a child or something, for example. So reasonable person must be in the shoes of the defendant. Um, yeah, and it confirmed that wickedly negligent conduct is criminal. And then we've got the cases for the omissions. So I've just broken it up into acts and omissions, so you guys can obviously tell the difference between the two. Um, so I think probably in the exam, and when you start doing past exams, you'll see that it's a lot of omissions that come from criminal negligence. So just keep that in mind that these you'll probably discuss these cases more than the ones with acts, just because criminal negligence is kind of really related to omissions. So Inston was she lived with and depended on her ill aunt, um, failed to feed or get help for her despite knowing her condition, um, and basically her failure to help her accelerated the aunt's death. And so here it was found that duty of care did exist because they knew the condition. They sort of it was sort of a voluntary assumption of assistance, and that's found with most of these cases. Same as Stone and Dobinson, these are really similar cases. So the defendants took in their sick sister, who later died from neglect. So they both owed a duty of care. So there was that family tie, and then the voluntary assumption of assisting someone as well. Um, and they were living with her. You know, they saw. I think she had anorexia. I can't actually remember exactly, but she had conditions, and she needed to sort of be followed, and they didn't do that. Um, it was found that the neglect was grossly negligent, and then tac as well. So we've kind of um, discussed that one. Um, in tac ultimately, it was actually found that the defendant wasn't guilty because there was a lack of causation. But you don't need to worry about that. Just know that if someone's secluding someone and, you know, not secluding them, like taking them up to their apartment or something, which means that they can't get medical help or they can't have other people help them, then it does amount to seclusion and a voluntary assumption of assistance. Cool. So right on time. So we spent 30 minutes of the content, which is exactly what I wanted to do. And then we only have one problem question for negligence. But yeah, it's kind of going to require a bit of a discussion, especially because it's relevant to both one and two. So both UDA, manslaughter, and then criminal negligence. So I want you to have a read of it. I will give you maybe 3 4 minutes and just start planning out what your answer would be. Pretend it's an exam scenario and you know you need to quickly write down what your plan would be. Um, and then we'll go through it together. Okay, so I hope everyone's had a chance to read it, and we'll go through the facts together again, anyways, just because it is really important for you guys to understand what facts are relevant. I think a lot of people sometimes miss out on that analysis as well, and like find some facts relevant, which maybe aren't as much. So let me just exit. How do I exit this PowerPoint? Okay. Maybe we'll do it like that. Cool. So I'm just going to put it as I always do, just in another document so I can actually write on it because I can't really write on the PowerPoint. Um, so we'll put it here. Okay, that's really annoying that it comes up. Just decrease the font. All right, that's fine. So Sophie and her friends are celebrating recent promotion at the bar. After several drinks, Sophie begins to feeling increasingly intoxicated. Is this relevant? Look, we'll highlight it, but probably not, because we are sort of looking at, and we're going to do intoxication next week as a defense as well. So just don't worry about that. But her friend Jake dares her to jump onto a table to show off her dancing skills. Despite being very tipsy, Sophie, in an attempt to show off, climbs on top of the table, climbs onto the table in the middle of a bar. As Sophie jumps down, so she's jumping down from the table, she slips on a chair that was not properly secured. In an attempt to steady herself, she grabs a glass bottle of alcohol from a nearby table. In doing so, she accidentally swings the bottle, striking Peter, the bystander sitting at the table next to her, directly in the face. Okay. Now, Peter immediately falls unconscious to the floor, bleeding heavily from a deep cut on his forehead. Sophie panics and stumbles away from the scene, leaving Peter lying motionless on the floor. Peter's friends call the ambulance immediately. Due to staff shortages, it takes 10 minutes for the call to be picked up and another 30 minutes for the ambulance to arrive. Peter suffers brain injury, which causes swelling to his brain, and dies a few hours later at the hospital. Um, and medical evidence shows that if he had received medical attention immediately, it is likely that he would have survived. Okay, so if you were answering this question in an exam, you would first talk about murder, um, and discuss causation, okay? Especially causation, because you can see, obviously, from the last bit of set of facts there, that that's sort of discussing causation. And, if he'd received medical attention earlier, he would have survived. So whose fault is it and all of that? Because we are not focusing on murder this week, I'm not going to go through the murder analysis. We've done one of those last week, but just know that you would have to do that in the exam. So we're going to go straight to manslaughter. So let's just say you write out basically what you would, you do your full murder analysis and then you go on the facts. Sophie is likely not liable for murder, and or you'd say, however, she may be liable for manslaughter. That's something you'd say, something like that, and then you go and do your manslaughter. So let's first discuss UDA manslaughter. So this is unlawful and dangerous act. I'll write it. I just always write UDA. You're allowed to write UDA in the exam, by the way, because it just takes so long to write that. So what is the act here that's dangerous? It's not her slipping on the chair, all of that. That's like, happens. It's the fact that she accidentally swings the bottle of alcohol. Okay. So what we would say, the act of swinging um, an alcohol, or maybe you can say a glass bottle, in Peter's face, um, is unlawful as it is. So here, let's just assume, we're just going to say that it is common law assault to, um, swing your bottle at someone's face, which it is, but then we need to obviously analyze if the mens rea and actus reus are made out, which probably aren't, but we'll analyze that. But you would say that swinging a glass bottle in someone's face is assault. And so say, and is hence in breach of the criminal law. Cool. And that's just from so say common law assault would subsequently become the foundational offence, and the prosecution must prove the requisite mens rea elements, mens rea and actus reus are elements of the offence. And that's from Lamb. Cool. So here then we would go. So the actus reus, you'd say the prosecution either needs to be proved battery or apprehension. So battery is relevant here. As Sophie applied unlawful force on Peter, namely to hit his face with the glass bottle. If apprehension is not relevant, don't discuss it. Like, it's most of the time it will be battery here. So, and there's a bit of, like, if you want to kind of substantiate that argument, you could include the quote from Collins and Wilcock, which says, the least touching of another in anger is battery. Now, it wasn't in anger here, but that's the next, we'll discuss that in mens rea, but that's made out. The actus reus is easily made out here because, there was unlawful force. Now we need to look at the mens rea. So here, Sophie's actions must either be intentional or reckless. It's hard on the facts here to make out recklessness. Obviously, intention would not be made out, as Sophie did not sort of subjectively intend to hurt Peter's face. That's pretty obvious. Or to apply sort of unlawful force on his face, you could say one or the other. So that's from Westaway. So this is a bit of revision for you guys for topic 4. Now, if intention is not satisfied, then you would say the court will turn to recklessness. And on the facts here, I think I probably would argue that it's not made out. Just because someone grabbing a bottle of alcohol from a table and accidentally kind of like swinging in the midst of doing that, accidentally hitting someone in the face, like, I don't think she was reckless as to whether her actions, like, she didn't have the likely foresight that she would swing someone in the face. Otherwise, she probably wouldn't have done it. So I would argue that recklessness isn't made out. And I think that's probably the stronger argument. I think it'd be really hard here. Think of this as in a real life scenario. If you were at a bar and did this, and then the court found that you were reckless and you were liable for manslaughter just from this first bit. Obviously, the next bit requires a bit of analysis, but yeah. So I would also say that recklessness isn't made out. Recklessness is unlikely to be made out, as Sophie, and if anyone has any arguments to say why it would be, then feel free to shout as well. But yeah, like in an exam scenario, you probably wouldn't say that it is. Sophie did not have the forethought. So this is the wording for recklessness. Make sure you word it like this. foresight of the probability that her actions would bring about the application of unlawful force, um, resulting in Peter being hit in the face. Hence, so then you would obviously conclude here then, hence the mens rea, the MR for common law assault cannot be made out. So then you would conclude, and don't be afraid to make such conclusions. I know it's kind of like, well, look, a lot of students always feel like they have to say, well, this is all made out, this is made out, this is made out, because they want to go through the whole answer. But they actually appreciate it more if something is clearly not made out, which I think here it wouldn't be. They appreciate it more if you go, well, this isn't made out, but I'm going to continue my analysis just in case it is. They do that. They do that on purpose sometimes to make an element very clearly not made out, and then see if students actually pick up on that or just go, well, everything needs to be made out because it's an exam. So yeah, say hence the foundational, hence there is no unlawful kind of yeah. However, I will continue my analysis. Um, you know, just because otherwise you're going to lose a lot of marks. Okay, so then let's go quickly onto dangerous act. So, sorry, I'm just going to make some subtitles. So, unlawful act here, and then we want to analyze the dangerous act here. So, obviously, even if this is made out, we still know that this manslaughter wouldn't be made out because it needs to be both elements. But yeah, we're just going to analyze dangerous act just in case. So when I say the unlawful act must also be dangerous. So the prosecution would argue, so Peter wouldn't argue because he's dead. So the prosecution would argue that a reasonable person, remember, in Sophie's position, would have realized that performing, or would have realized that swinging a glass bottle in a bar, and I think it says that the bar's like kind of, doesn't say it's full, but in a bar with nearby tables and people, um, with nearby people, would expose bar customers to an appreciable risk of serious injury. Wilson. So this is an objective test. I think, once again, here it's a bit hard to argue because we've already made the argument beforehand that it wouldn't be made out the mens rea. So it's reasonable person in Sophie's position. So Sophie was intoxicated. So I guess you could say, and we'll look at intoxication next week. That's why I'm not really bringing it up. But a reasonable person who's intoxicated maybe wouldn't realize that. This can be argued both ways. So I'm actually going to let you guys come to the conclusion. I guess if it was me arguing in an exam, I probably would say that dangerousness is made out. However, the act is not unlawful because obviously the mens rea is not made out, and hence Sophie would not be liable for UDA manslaughter. Okay, now, is that the end of it? No, because there's two types of manslaughter, and the other one is actually highly relevant here. So that's the first bit, and now we are going to go on to criminal negligence. And she would probably be found liable. Yeah, well, I'm not sure. Let's do the analysis. So first of all, she must have owed a duty of care. So that, remember, that's the first aspect. So did she owe a duty of care? So the prosecution must prove um, that Sophie owed a duty of care to Peter. Um, prosecution will argue that first of all, Sophie. So I'm going to come up with a couple of arguments. You guys can choose which ones to do. They're all relevant. But first of all, Sophie had a general duty not to harm others. Okay, that's like the main kind of baseline thing, that you have a general duty not to harm others. So that's from cool. Um, but what specifically are we looking at here? So are we looking at the act of her swinging the bottle and doing that, or are we looking at the fact that she stumbles away from the scene, leaving Peter motionless on the floor? We're probably looking at this omission, right? Because um, as I said, with criminal negligence, most of the time it is going to be relevant. The omission aspect is going to be relevant because someone had a duty to do something, but they didn't actually do it. So we're going to leave the act of swinging the bottle behind, and we're going to focus on the omission bit, okay? So the next argument here then is that there's a duty, and this is from the Miller case. So when I think someone started a fire and then they didn't put it out or something. So there's a general duty. There is a duty to take measures to counteract a danger that one has created. So obviously here, Sophie was the one that created the, I guess, hazardous situation. She was the one that swung the bottle and hit Peter in the face. So yeah, it's like if you go and punch someone and then leave, because you're the one that created the dangerous situation. So it's your responsibility to kind of, I guess, resolve it in a way and not leave the person, the victim, there lying motionless as she did. So that's the one that's probably most relevant. The other duties aren't relevant. So the other duties are the familial relationship, which, here they're strangers, so that wouldn't be relevant. The duty for a person who cannot care for self, that's also probably not relevant because all his friends are around, as we see in the facts. And, it's not like those are more the cases where someone takes someone into their house and then doesn't like feed them or doesn't provide assistance to them and then they die. So that's not relevant here. The other duty is duties imposed by a statute or contract. Once again, probably not relevant here. There's no duty, there's no contract, no statute. So yeah, this is the one that's relevant. So we've kind of made out that first bit, which is that, she's got a duty to take measures for what she's created. So that's nice and easy. Now, the second aspect of that is the obviously the act resulted in death. I didn't really usually write this element because it's kind of obvious that it did. Otherwise, it wouldn't be a question. So you can kind of skip over that. But then the next kind of substantive factor is that the act or omission breached that duty of care by criminal negligence. So that threshold that the Neum case developed. So what we would write here is the prosecution. Oh, sorry, I don't want to make it. So the prosecution must prove that they breached the duty of care by criminal negligence. So that's really important. It's not just breaching a duty, it's got to fulfill that threshold. So namely, Sophie's conduct, here we probably want to say more omission, not conduct, involved such a great, and this is from the quote, the really long and annoying quote, that you need to kind of say or paraphrase. Such a great falling short of the standard of care which a reasonable person would have exercised in the circumstances. Okay, so you need to say that. Moreover, the omission involved such a high um, risk that death or serious bodily harm would follow. So that's how I said before, if you guys, you need to probably try and find a good way to paraphrase it. That's how I paraphrase it for my exam. So probably have that in your notes somewhere. Like that's how you write it in the exam. Um, Now, what would we say here? Well, likely, if someone, um, on the facts, we probably say on the facts, a reasonable person who has accidentally injured someone by sort of, I guess, swinging a glass bottle in their face, um, would have likely, um, gone over to help them, or sort of would have likely um, helped them, or at least investigated as to whether they were, they were fine, or they were injured. Um, so if you did not do this, right? So what did she do? She panicked and stumbled away from the scene. So we could say Sophie departed from what a reasonable person would have done in the circumstances. So what did she do? Um, she, she stumbled away. She panicked and stumbled away from the scene. And then we need to, so that's for the first element. I'm just going to like put it in colors so you guys can see what I'm directly referring to. Oh, that's not, you can't see that. Let's do it like that. So that's that element there. So what a person would have exercised in the circumstances. And then we need to make out the second element. Okay, that's really annoying that they're different colors. Okay, and then we need to make out the second element, which is this one here. So the omission involves such a high risk that death or seriously bodily harm would incur or would follow. Now, we can probably make that out as well, right? Because it says here that he was lying motionless on the floor. So you'd probably say, arguably, um, leaving, arguably, swinging someone in the face with a glass bottle um, and leaving them lying motionless. And I think it was he bleeding as well. I think it says he was bleeding, full conscious, bleeding heavily. Yeah, so leaving them lying motionless and bleeding heavily um, involves a sort of a high risk that death. It doesn't need to be death. It involves a high risk that probably serious bodily harm would follow. You could even say death here because, if someone's lying motionless, like, and unconscious, um, yeah. So you could even include the unconscious bit as well. So there's so many factors that go into it. Motionless and bleeding heavily involves a high risk that death would follow. So we've kind of made out those two factors. Now, the last sort of thing that we probably want to quickly talk about here is, and just so you include more cases, is that Sophie must be compared to a reasonable person of her age and experience, compared to, I guess, a reasonable person of her age, experience, and knowledge. Knowledge. Cool. And that's from Lavender. Um, in the same circumstances. So I guess once again, the reason I'm putting this in is because the argument of intoxication could be made out, really, but not made out, sorry, could be raised because I guess she was increasingly intoxicated. So you'd look at that. But next week, we will look at the fact that if someone's intoxicated, it doesn't really matter, especially if it was self-induced. So she's the one that was drinking and all of that. Um, yeah, I, you probably wouldn't really analyze that as well. Like you'd probably just include it in there so that you know you've shown reference to the lavender case. And yeah, but that doesn't really need to be analyzed. So we've made out those two factors because she had the duty to kind of she breached that duty of care by criminal negligence, and then that resulted in the death. And so you would say, hence, involuntary manslaughter by criminal negligence is satisfied. And so Sophie would be liable for this one. Cool. So that's the whole analysis. So yeah, I hope you guys have kind of written that stuff down or, taken screenshots or whatever. But you can see that, yeah, you kind of need to go through the whole thing, but there's not too much to discuss. And this would be enough for an exam. Um, yeah, I feel like, you might expand on a couple of points, but um, the general kind of thing would be enough for an exam. Cool. I'm going to stop sharing my screen. There's no more slides on here. Yeah. And yeah, I guess I'll hang back for like 5 minutes. If anyone has any questions, then I do have to get back to work. So if you've got any questions, feel free to ask now. Um, yeah, and if not, enjoy your weekend and your last 2 weeks of uni.
I just wanted to ask,
Yeah.
the idea that obviously you discuss murder, and then if that's not satisfied, it's the unlawful dangerous act. But then if the unlawful dangerous act is satisfied, you don't do criminal negligence.
No, because they could both be made out in a case. Um, yeah, like if for example, Sophie in this scenario had the mens rea for the common law assault, we would have made out unlawful and dangerous act, and then we would have also made out the criminal negligence. So just discuss like yeah, discuss everything if it's relevant. If the criminal negligence really isn't relevant on the facts, then you probably don't need to. Um, but most of the time it will be. But yes, if it's not relevant on the facts and you've made out unlawful and dangerous, you can just add a sentence saying, here, I'm not going to discuss criminal negligence, manslaughter, because there's nothing on the facts to suggest that this would be an issue or something like that.
Yeah. And then for when we discuss murder, we're covering like the voluntary act and causation in murder. So you don't need to mention those again when you're moving on to the unlawful acts.
Yeah, that's right. Yeah, yeah, that's right. Yeah, but I guess you could just say like I refer back to my analysis on causation before or something like that. Um, just to note that you've done it. But yeah, it's all
Yeah.
right. All good.